you. Okay, we're back on the record. Councils, thank you for your patience. I had to take up some business. It took a little bit longer than I expected. So I think we left off with page 140, line 11 to page 143, line 16.
Yes, Your Honor. And I'll just play that portion. And it should begin at approximately 11:16:19 through 11. My numbers might be off. Hold on one second. 11. Something's wrong. 11:16.
I'm sorry, what part of the day you're
Okay.
playing from?
It
I'm
should be
sorry.
11:16:19 to 11:18:17.
This is the page 140.
Yes, page 140, line 11 through page 143, line 16.
Oh, okay. All right.
When you shot at Taylor, yeah. This why I didn't get a chance to get out the gun, that you ain't give me the gun today. You know?
I'm gonna go back, Your Honor.
But the gun that I had shot at him with, that was Shannon gun. When you shot at Taylor, yeah. That's why I didn't get a chance to get out the gun, that you ain't give me the gun today. You know? When the police came to the house, Shannon right there. You didn't come. Shannon right there. What was the gun? The gun right there. You know what I mean? The gun was right with it. The gun just like I never took the gun over. I was so scared and I just like I'm just defending it. Right. So where was the gun when the police got there? The gun was like I had put it in the house. You know what I mean? So when I was asked what the gun was, I'm like, shit, I can get it. Like give it to me. The Shannon went in there and got the gun and left with it. I mean, so that's why I'm like, give me another thing. That's why what kind of gun was it? Huh? What kind of gun was it? A Glock. A Glock, what, 40, 9? It was a 40. About this long. And that's why you had to, when they got the magazine. The clip, yeah, the clip. I mean, so it was Shannon's gun, but when the police asked for it, he didn't want to give it back. Right. I ain't gonna give it to him about the new kid. I was gonna give it back though, because I didn't want to go to jail for it. Right. I mean, so when Shannon went there and got the gun, that's why I told her I wanted to tell her, like, let me talk to you, when I talk to you, and you like, get you that gun. But when I tried to get the gun, changed it, he wouldn't give it to me, then he went on the show with Thor, he left. But that's not exactly what you said. You said that K or D or somebody you wanted to purchase the gun for. No, he getting wrong. Okay, well, you said it's not the Glock. From the night of the shoot. Yeah. They shot at your girl morning. Yeah. Right. Shannon left with the gun. Okay, well, this is the first you telling us about that. I'm just going. Nah, I told you. I just like somebody that can't got the gun. Right. You get it? But right. Shannon who got the gun. He still got the gun though. What do y'all use to get all these guns?
We're stopping at 11:18:20.
All right, Mr. Sharp, sir.
So a couple things that I object to with this. Obviously, it's character evidence about my client owning and possessing a gun based on my client's status as a convicted felon at that time. That would be an illegal act. We have not been given any 404B notice about this previously. So that's my first objection. It's not charged conduct either. And finally, a foundation hasn't been laid to play this portion of the tape. The state did not confront Mr. Copeland and say, in the interview on June 10th, 2015, did you tell Investigator Gaither that after being shot out, that outside your house, Shannon, that was Shannon's gun, Shannon took the gun, Shannon wouldn't return the gun, etc. He's never been confronted with those prior statements, so I don't think the foundation's been laid for either.
As to Mr. Copeland.
Right. I don't think the foundation's been laid for either prior inconsistent statement or impeachment by contradiction.
Is there a requirement that the declarant be confronted as to that?
Yes.
In this particular circumstance?
I would, yes. That's definitely for prior inconsistent statement. But again, I don't know how a contradiction can be established without first getting the side of the story that you claim is being contradicted.
You hold on one second. All right, Mr. Shard, anything else, sir?
I know.
Okay, Mr. Steele, anything, sir?
Just adopt the same, can't just play the recording.
Okay,
No foundation for it. Thank you.
all right. Anybody else? Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No. Yeah.
All right. Misty Williams? Mr. Harvey? Okay, all right. Okay, State, why do you believe it should, I want to hear it, but why do you believe it's admissible?
Okay. So, Your Honor, first to address that the foundation has not been laid. Yes, the foundation has been laid about the gun. In any of his statements in these,
How has the foundation been laid?
because when he says, I don't remember anything that I told the police, coupled with everything that he is saying, he made it all up. That is the foundation to which we get to play his prior statement.
Does he have to be, confronted
No,
with it, as Mr. Short mentioned?
he does not. The moment that he says, I don't remember anything, we can confront him with all of his statements, especially when he says, I don't remember anything I told the police and everything I said to the police, I was just making it up. We don't have to confront him with every single line in his statement, and I'll find the specific case law that states that.
Yeah, do you have any case law which would indicate that this is one of the exceptions where he does not have to be confronted as to his statement?
Yes, we'll pull that. So while we're waiting for that specific case law,
All right.
further,
And what else?
when
what-
he says that the fact that Mr. Stillwell possessed a gun is not bad character in and of itself. So, Your Honor, I would like to direct you to 3 cases. The most recent is going to be Hill v. State, which is 2024 Georgia Lexus 140, which was decided on June 11, 2024. And specifically, that case talks about the fact that someone has a knife. Is not bad character, but they cite the Adams v. State case, which is the next case I want to provide to the court, which is Adams v. State 318 Georgia 105.
318 Georgia 105.
Yes, which is also a 2024 case.
All right.
And what it says is specifically that given that gun ownership and the custom of carrying a gun do not by themselves impute bad character. So solely for the fact that Mr. Copeland is saying that Shannon had the gun, that in and of itself is not bad character evidence. It would not impugn Mr. Stillwell's character. But even if the court thought it was impugned on his character, Your Honor, this is intrinsic evidence in which would be admissible because this is inextricably intertwined with the evidence regarding the offenses in this case and is necessary to complete the story of this overall crime. If you can recall, Your Honor.
Did we have a hearing about this earlier?
It doesn't have to have a hearing. So intrinsic evidence does not have to have a hearing. And specifically, I'm citing from Johnson v. State, which is 312 Georgia 481.
Said 312 Georgia.
481.
Okay.
Evidence pertaining to the chain of events explaining the context, motive, and setup of the crime is properly admitted if it is linked in time and circumstances with the charged crime. So, Your Honor, here the charged crime is the murder of Donovan Thomas. As we've been discussing, after Mr. Thomas was murdered, there were a series of events that occurred. One is the shooting of Mr. Copeland with his child and his child's mother, which the court has heard testimony about. In his February 21st statement, Mr. Copeland talks about this gun, the gun that he used to shoot back at Tay, or shoot back at those who were shooting at him. And if you can recall that they kept asking in both the February 20th interview and the February 21st interview, where's the gun? Where's the gun? We need the gun. We need the gun. We need the gun. And what he's finally explaining in June is that the gun that they were asking for was Shannon's gun, and that Shannon had took it to Miami. That is why he could not give the gun back to the police. So
That's the same gun he said he was gonna go get, and he never did.
Yes, Your Honor.
They came and arrested him again.
Yes, Your Honor. And the reason why he could not give them the gun is because Shannon had took the gun with him to Miami. And now,
I don't think that's accurate based on what was said. I think he said Shannon's in Miami. I don't think Shannon's gun was.
I believe he does say that Shannon.
He says in the transcript.
Yes.
I think, Mr. Sharp, I think that, let's see. Well, he says, remember, this is page 142. Mr. Copeland purported speaking. You know what I mean? So when Shannon went in there, he got the gun. That's why I told the detective, let me talk to you. When I talked to you, he was like, get you that gun. I remember I tried to get the gun. Shannon says he wasn't giving it to me. Then he went on the show with Thuggy Left.
And if you go to page 143, Your Honor, he further says, and maybe I made the inference, Shannon left with the gun on page 143, line 7.
Yeah, Shannon left with the gun. That's
So
okay.
I just deducted by inference that Shannon left with the gun when he went on the tour with Thug, Your Honor.
Okay.
So, Your Honor, we believe that it comes in, one, it's intrinsic evidence. Two, it's not bad character in and of itself, the fact that he possessed the gun in this case, and also citing Williams v. State, 302 Georgia 474. And I'm just going to read this last line. Intrinsic evidence remains admissible even if it incidentally places the defendant's character at issue. Again, we don't think that Mr. Stillwell's character is at issue, but if the court thought it was, that the fact that it's intrinsic to Mr. Copeland now further explaining why he was unable to turn that gun in, it would not be an issue if it incidentally places Mr. Stillwell's character at issue, but we don't believe that this is character evidence at all, given that solely the fact that he possessed the gun in and of itself is not bad character. And Your Honor, regarding the assertion about whether or not we have to confront Mr. Copeland line by line, I'll cite the court Bridgewater v. States, 309 Georgia 882 at 887, which is a 2020 case.
You said 309 Georgia 882 at what?
At 887. Oh,
All right.
and again, Bridgewater specifically addresses prior inconsistent statements. However, we believe the principle remains the same for impeachment by contradiction, and that we do not have to go line by line once Mr. Copeland has denied, remember anything he said in his prior statements, and has said that everything he said, he made it all up, or he made it up, that we do not have to go line by line to impeach him with every single line in his prior statement.
All right. Okay. Mr. Shaw, you rose. Anything else, sir?
Yes, sir. My colleagues are looking at the Bridgewater case, but regarding whether this is character evidence or bad character evidence, to my understanding, the cases that are cited by the state are a little bit different than the facts here, and simply because, yes, I understand it is according to the Supreme Court of the United States and according to the Second Amendment, it's pretty much everyone's right, citizen of the United States, to have possession of a handgun subject to certain restrictions. However, Mr. Stillwell, it can be distinguished, his situation can be distinguished from the individuals in those cases that the state cites. And that's because Mr. Stillwell is a convicted felon, meaning his possession of a gun would per se be a crime. And the jurors, as the state has made it clear by admitting probably 4 prior convictions of Mr. Stillwell, they've made it clear to the jury that Mr. Stillwell would have been committing a crime if he was in possession of a firearm at that time. So that's the difference. It is bad character evidence. All of this is subject to 403 balancing, and I'm not sure what probative value. Again, the state is labeling this as intrinsic. We have a murder case from January 2015. Then we have an unrelated shooting case upon Kenneth Copeland at his house, which happens approximately a month and a month and some days later, the state, I understand their theory, but there's really been no hard evidence that shows that these two events are at all linked. So now we're getting into the weeds of what happened to a gun in an unrelated shooting that happened around the same time, where the target was Kenneth Copeland, and what happened to the gun that he used to shoot back at the people that were shooting at him. We're way off in left field at this point. These are collateral matters, and the ownership of the gun that Kenneth Copeland was shooting on that day when people were shooting out of a car at him is of very limited probative value as to who killed Donovan Thomas on January 10th, 2015. And I think we need to keep that in sight and what we're actually trying to prove and what this case is about. The February 20th shooting that this gun was used in is not charged conduct in this case. And now we're getting into the weeds about whether this was potentially my client's gun that was used. And again, there's prejudicial harm towards my client that comes along with that information being given to the jury.
All right, sir. Mr. Steele, go right ahead, sir.
Your Honor, I think that the state's reliance on Bridgewater, BRIDGWEATER versus State 309 Georgia, 822, it's in Division 2, 2020 case is off the legal mark. This case in the fourth paragraph, our highest court specifically wrote, Bridgewater further challenges Davis's out-of-court statements to Thornton as recounted by Thornton, arguing that the state failed to ask Davis any specific questions about those alleged statements and did not identify the substance of those statements. As a result, Bridgewater argues Davis was never, and this is from the statute, which is 24-6613, afforded an opportunity to explain or deny prior inconsistent statement to Thornton, and the defense was unable to interrogate Davis about them. We disagree, and here it is, Your Honor. On direct examination, Davis expressly denied knowing Thornton and denied ever speaking to him. Although Davis appeared to contradict himself by saying that Rashawn, which is RASHAWN, gave him a ride to Short's mother's house, the prosecution later asked whether Davis recalled any conversation with Rashawn Thornton at all, and Davis replied no. And this is what the holding is. Davis's unambiguous denial that he had ever spoken with Thornton, as well as his assertion that he did not recall ever speaking with him, obviated the need for the prosecutor to ask Davis about specific statements made to Thornton and to provide specific foundation for the state to present extrinsic evidence of such statements. And Your Honor, here, what we have is Mr. Copeland never said, I denied speaking with the authorities, or I deny ever discussing Mr. Williams et al. With the authorities. He is saying actually the opposite. I probably did say all that. Let me explain to you why. So the state's reliance on Bridgewater respectfully is not on point. And then in Bridgewater is cited in Rozier, which is ROZIER.
Mr. Steele, can I ask you a question? No, it looks like I think it's going to be page 886. it's got, Bridgewater further challenges Davis' out-of-court statements to Thornton as recounted by Thornton, arguing that the state failed to ask Davis any specific questions about those alleged statements and did not identify the substance of those statements. As a result, Bridgewater argues that he was never afforded an opportunity to explain or deny his prior consistent statements to Thornton, and the defense team was unable to interrogate Davis about them. And they cite 24-6-603, and they state the appellate court states that we disagree. So how are you saying that's not applicable or potentially applicable here?
If you just go the next two sentences, specifically, Mr. Davis, the witness, denied ever making a statement to the police at all, and denied ever even knowing one of the parties.
Well, isn't that kind of similar what we have here in terms of Copeland saying, hey, I made up this stuff, or worse to that effect.
I think it's diametrically opposed, because Mr. Copeland's saying, I actually did say all this. His words, I believe, are, I probably did. I was making it up.
Well, I think he says that, but I think he also says I made up a lot of stuff just to get out of jail. So,
well, I think that is in concert. So they hold hands. I think the way I understood it, I'm not looking at a transcript. Mr. Copeland said, I probably did say that. I would do anything to get the authorities to take the target off me and put it onto someone else. That's how I understood basically the totality of his testimony. So he is not denying. Mr. Davis here said, I never spoke to the police. I never spoke with them. So that is a blanket denial that he said anything. He also said, I don't know this person. That is a blanket denial that he could talk about that person. So the state, in that case, in Bridgewater, did not have to go line by line, question by question, and say, well, didn't you say this? Here, I think we are jumping the curve and allowing the state, based upon their desire, I guess, not to lay a foundation the way I understand the law, and just say, well, he said, and the state keeps saying the same thing, and the court keeps saying that's not what he said. The state keeps saying, he said, I lied about everything.
that's what the state told me.
They keep telling you the same
yeah.
thing day after day. That is not what the court heard. It's not what I heard. Where Attorney Adams, he's saying, shaking his head, yes. He's just explaining it. But if they want to get in a specific, like Shannon had the gun, Mr. Jackson, excuse me, had the gun, then I would also join Mr. Shart and say that he needs to be given an opportunity to say, did you say this? And then he'll say, I assume, yes, I did say this. Why did you say it? Because I lied. And then you don't have to play the recording.
I'm going to ask you one other question. What say you about the extrinsic evidence argument from the state?
I think that it's specious. I think that, and I could give you the case right now, actually. I just have to flip my computer. What Mr. Shart said is right. This is not, yes, gun, if I possess a gun, there's no problem. I could possess a gun like I could possess this highlighter. It's not bad character. But Mr. Jackson, in this case, is a convicted felon before this June 10th, 2015 interview. So clearly that is a criminal activity. So I think that answered your question. So I do believe that it is the character, inappropriate character of Mr. Jackson.
Okay, thank you, sir. Anybody else? Okay, state.
Yes, Your Honor. So as it relates to the prior inconsistent.
Let's talk about Bridgewater first. What's your take on that?
So again, Your Honor, Bridgewater is a prior inconsistent statement case. We are at impeachment by contradiction. He says he made everything up. So there, even if he didn't say the word lying, he said, everything I said back in 2015, I made it all up so I can get out of jail. So now the jurors get to see what he said previously in order to determine if they believe him in court or if they believe him when he testified, when he talked to police back in 2015 that he made it all up. Second, so that's first and foremost as it relates to my response to Bridgewater. We use it as an example of whether or not we have to go line by line, but for the same principle, if we're impeaching him by contradiction, we are saying what he told this jury in 2024 is contradicted by what he was doing in 2015. So that answers the first question as it relates to the Bridgewater analysis. And I think, and I would need Ms. Weaver to check, I believe when prior to the February 20th interview, before we started playing that interview, I thought I asked Mr. Copeland about what happened with the gun, but I would need to double check that. I don't want to say it, but I thought I asked him what did he do with the gun, and he denied giving it to Shannon, or he denied what his response was. But I would need to check the transcript for that.
What about the issue asserted by the defendants about Mr. Stillwell being a convicted felon? And because you cited a couple of cases for that particular proposition: Adams versus the state, Hill versus the state, and Williams versus the state. Johnson versus the state.
You're right.
Is that different because Mr. Stillwell is a convicted felon? I mean,
No, I don't believe, and I was looking at another case, Hollis v. State.
Hollis, Hollis v.
Yes,
State?
Hollis v. State, to look at
What's Hollis?
359 Georgia App 249.
Is Georgia Appeals or Georgia?
Georgia Appeals 249. To see if in the facts of that case, if the defendant Hollis, I believe in that case, defendant Hollis may have been on probation for a crime and he had a gun, and the same proposition was the same, but I need to look back at the facts of those cases. And I'll wait till the court looks at Hollis. in reading answers, I think there's something else for probation. So I have not found a case out of my point. Speaking directly to the issue of Mr. Stillwell being on whether or not the fact that Mr. Stillwell being on probation would impugn his character, but Your Honor, the state will go back to the Johnson v. State case, which is about inextricably intertwined evidence, Your Honor. And again, not forgetting that the prosecution that's currently going on is not relegated only to the murder of Donovan Thomas. We are in a RICO conspiracy. And so the sole fact that Mr. Copeland, in the midst of a retaliatory shooting in which the opposition gang believes that he killed one of their gang members, uses a gun that was given to him by Shannon Stillwell, is one inextricably intertwined into this case. And although it's inextricably intertwined, and although it incidentally places his character although it places Mr. Stillwell's character at issue, it is inextricably intertwined into the overarching story and conspiracy that we are attempting to prove in this case, Your Honor. And here in the Johnson case specifically, this court let in an entire aggravated assault shooting as intrinsic evidence.
Is that Johnson at 312 Georgia 481?
Yes, 481.
right.
And interestingly enough, this case involves the Atlanta Blood Gang as well. But here, the court let in an entire aggravated assault shooting as intrinsic evidence.
But I think that, like, let me go back to Adams. I think Mr. Shart's argument is his specific grounds of objection are that his client is a convicted felon. So,
and so that's why the fallback plan, or not the fallback plan, but that's why if you think that that is a character issue, what Johnson v. State says is if an act is inextricably intertwined, one, it comes in, and then two, when I cited the court to Williams v. State, 302 Georgia 474, intrinsic evidence remains admissible even if it incidentally places the defendant's character at issue. So even if you believe that his character, which the state still contends that it is not, because it's intrinsic, even if it incidentally places the defendant's character at issue, it would still come in. This incident in which Mr. Copeland is now explaining to the investigators why he was unable to turn in this gun is inextricably intertwined into the series of events that occurred. Defense counsel has made it an issue that Mr. Copeland has been lying throughout this entire interview. So this gives a reason why he was unable to turn in that gun.
We haven't even crossed Mr. Copeland, so I don't know. I haven't called Mr. Copeland.
Mr. Steele's argument all last week is the reason why some other rumors are going to come in is because they want to show that Mr. Copeland lies in this interview. That was the exact argument last week as to why certain non-relevant portions of this interview should come in.
Ms. Hilton,
Mr. Shaw?
I'm just seeing if you were
Oh, yes.
finished. Okay. So, Your Honor, couple things I disagree with. First of all, this is not intrinsic. The state can say, oh, well, this is a RICO conspiracy. We are dealing with the January 10, 2015 Donovan Thomas homicide, and that's allegedly what all this is related to, according to the state. But even if we took an expansive view, this indictment alleges, I should know the number, near 200 different overt acts. 191, okay? This February 20th shootout outside Kenneth Copeland's house is not one of the alleged acts. So we are now going into the minute details and collateral information about a act that isn't even among the 191 acts charged. Secondly, even if we were to label this as intrinsic, which I don't believe it is, the state said it's admissible as long as, even if it incidentally puts the character of the defendant at issue. This is more than incidentally.
Let me just engage in a little conversation. Ordinarily, you'd be right, but there's a background in terms of this gun that the jury's heard and is continuing to hear in this particular case, and that being is that in the interview he says, well, Copeland, I was telling the police anything they want to hear because I want to get out of jail. I'm gonna go get that gun. This kind of fills in that particular narrative about this particular gun. So it is kind of, it's relevant, and it is kind of inextricably kind of intertwined in that respect. And,
Well,
and it kind of in looking at Johnson at 370 at 312 Georgia 481. Evidence is admissible as intrinsic evidence when it is an uncharged offense arising from the same transaction or series of transactions charged offense. 2, necessary to complete the story of the crime, or 3, inextricably intertwined with evidence regarding the charged offense. It's like Smith versus the state. So in this particular circumstance, I think that's why they're trying to complete the picture about the weapon.
I understand what.
Okay, and I know you fundamentally disagree, and
Well,
I'll take that.
Let me just say a couple things. First of all, this weapon, I think this is important to know. This gun is not involved allegedly in any other crimes or acts. So there's no loose ends that need to be tied up later with who had this gun or where was this gun. This gun, the story about this gun ends here. Okay, so there's nothing else that comes up about this gun. But secondly, when we're talking about, and this is why I said incidentally places character evidence. Okay, I've already distinguished my client is a convicted felon. It's character.
Do you have any case law that,
this is
that specifically shows that, and you can invite me to look at about a convicted felon?
Well, I think it's pretty clear. I mean, evidence of someone committing an uncharged crime is. But
I asked you if you had a case.
I can look.
So I could. I mean, that would help me kind of decide this. But it looks like from looking at Johnson that even an uncharged offense, can be considered
I
for the proper
understand that.
purpose.
I understand that, but this is when we get to the level of prejudice and
I have to I'll make a 403 balancing test in that respect, because you're absolutely right. I'm supposed to do that.
And I just want to point this out. Not only would the jurors be hearing about my client committing an uncharged crime, but the most important thing that I'd ask you to consider is my client, this uncharged crime, which they're going to hear about through a videotape of my client committing. My client is charged in this indictment with 2 counts of that exact crime. So they're going to hear a videotape of Kenneth Copeland talking about my client, Mr. Stillwell, committed possession of a firearm by a convicted felon. They're not supposed to consider that for propensity, I guess. But then at the same time, they're going to be asked to weigh in on his guilt or innocence of 2 separate counts of possession of firearm by a convicted felon. To me, that increases the prejudice because, I mean, it's obvious if you were charged with check fraud and you know someone brought up that you pushed a lady down the stairs one time, yeah, that would be prejudicial. But if they bring up the fact, oh yeah, he's been convicted of, or he committed check fraud on this day and committed check fraud on that day, and then we say, hey jurors, what do you think about Mr. Stillwell? Do you think he's guilty of these check frauds? Of course they're going to say yes, because they're going to have heard about these prior uncharged acts. So that's what I'm dealing with. The uncharged act is exactly what he's charged with in this indictment.
Okay.
And that increases the prejudice.
All right, you're saying just the fact that the state's trying to complete this. So you're saying the state's trying to complete this story about this weapon, and this weapon is not used in any way
There's no
in this
story.
particular case?
There's no story to complete about the weapon. The weapon is a dead end. Nothing happens with that weapon. I could see if this weapon was used in another crime and they need to track it. This weapon is not part of the story at all. It's not intrinsic. It's a dead end.
Well, and I'll weigh that, but I think they're saying it's intrinsic to the fact of this completion of the weapon. I understand now. I understand your point is it's not really it's not this is not the gun that's charged with anything in this case.
Right. There's no ballistic matches.
All right. Okay. State.
Your Honor, again, the state's intention is not to impugn that this gun was used in any other offense. It is solely to complete when Mr. Copeland says, I told you all I was going to turn in a gun. The gun that I was supposed to turn into you all, I did not turn it in because it was Shannon's gun. That is what we're trying to complete, because again, defense counsel will purport through whether it's their cross-examination, but what they have indicated is that they want to show that Mr. Copeland is a liar. Mr. Copeland is now explaining to the detectives, in February, I told you all I was going to give you a gun. I never gave you all a gun. Well, let me tell you in June why I didn't give you all the gun. I didn't give you the gun because it was Shannon's gun. And Shannon took the gun with him. And that's why I could not give it to you all.
But
there's a reason behind the gun.
But what it does is, nobody's been able to kind of tell me otherwise that being a convicted felon. I mean, I know it's a status offense, but.
But even looking at Johnson, Your Honor, the Johnson case in which they're allowing an intrinsic act of an aggravated assault, the case itself was a murder case. And they allowed into evidence another aggravated assault. It was a murder and a shooting incident at a gambling house.
Uncharged aggravated assault. Or
yes,
one,
it was
the one that was on charge in the indictment.
It was uncharged. It was uncharged in the indictment, and they allowed it an entire.
It was not charged in the indictment.
It was not charged in the indictment. So here, Your Honor, we're not asking for a crime to be admitted. We're asking solely for the playing of the fact that the gun was not turned in because it belonged to Shannon. Shannon went on tour with Thug, and he went to Miami. We're not even saying that.
Okay. All right. Let me say about that. What about Mr. Shart's argument about it? I have to do then a 403 balancing test. Is it more probative than prejudicial? He's saying you've already charged Mr. Stillwell with 2 counts of possession of firearm by a convicted felon, which are going to be brought up later on. He's saying this increases the prejudice. So what would you say about that? Because and I'm listening to it because it's a road to nowhere. It's kind of like in terms of what you have to prove. It kind of just the jurors may think, well, this guy's who's a convicted felon has this gun and it's not really involved in anything that's charged in this case.
Your Honor, Mr. Stillwell is charged with a murder in 2022, and that's one of the offenses.
Okay, but is this gun tied to anything?
the gun is not tied, but trying
Okay, that increases the prejudice though, because if it's not tied to anything, I mean, I understand what you're
the
saying,
gun.
but
Sorry, I apologize.
no, go ahead. I'm
No,
apologizing.
no, you
Go ahead.
go. I'm sorry.
No, what it does is it increases the prejudice in terms of, because you don't want the jury confused on the fact of, okay, we've heard Shannon's got a gun, or that Copeland's saying, hey, Shannon, the reason I didn't turn it in is because Shannon took it and he took it down he took it. But it doesn't go anywhere because it's not used in anything other thing. It's not used in any other criminal offense. It's not tied to a murder. It's not tied to anything. It's just the fact that this shows where this gun went on a guy that's already who's a convicted felon, and it's not charged in the indictment. I know I could probably let it in, but my concern is Mr. Sharp's concern, and that's whether or not it's more prejudicial than probative, given everything that he's charged with. Is this going to confuse the jury or let them know, hey, he's, what about this weapon when it's not tied to anything in the indictment? I mean, I know that Johnson seems to indicate that, but so tell me how I get over the 403, given what you charged Mr. Stillwell with in this indictment.
Sure, because the state has not asserted and will not assert that this gun that Mr. Copeland used in 2015 is the same gun used in 2022. It's a 7-year difference between this particular incident in 2015 and what Mr. Copeland says. The only purpose for this portion is to complete what happened with the gun, especially given this notion or this idea that in 2015, Mr. Copeland was just lying about everything. So we as the state had to show, we believe that in 2015, his statements were credible. He gave a reason for what happened with the gun. I believe that Mr. Sharp's trying to confuse issues as to the fact that Mr. Stillwell is charged in the indictment with possession of a gun. That is separate and apart from the purpose in which this particular piece of evidence will come in. It is solely to complete what happened with the gun that Mr. Copeland used in order to defend him, his child, and his child's mother. The state has no intention of saying this Glock was used in some other crime because we don't have any evidence towards that. Furthermore, when we talk about what happened in 2022, as the court will instruct the jury, they have to look at every crime individually. So when we get to 2022 and the murder that happened in 2022, the jury is going to have to look at the evidence for that particular crime, in addition with the RICO, independently of whether or not Mr. Copeland used this gun to fire back at individuals who were shooting at him. They're going to have to parse out that evidence for themselves.
That's a separate issue other than Mr. Stillwell. I hear what you're saying. I mean, I tell you what I'm going to do. I'm inclined to apply the 403 balancing test and find it's more prejudicial than probative. But here's the defense. If you open the door as to it, I'm gonna let them bring the truck. So you got to be very careful about not opening the door about this particular issue and this weapon, okay? Because if you open the door as to it, I agree with you, Mr. Sharp, Mr. Steele, that it is more prejudicial than probative. But if you dance around the issue and open it up, I'll revisit my decision. Okay.
Yes, Your Honor.
All right.
And then, Your Honor, can we then ask him if he gave the gun to someone? Because I believe that it is important that the jurors know something happened with this gun in which he expressed that to the officers back in 2015. I mean, not to say that it was Shannon, but to say that.
I think you gave the same issue about if you name Mr. Stillwell.
No, we're saying not to name him, but, and I don't know what Mr. Copeland's response will be in court today, or in court whenever he comes back. But to ask him specifically, did he give, without telling me who, did someone take that gun. I mean, because I believe that we have to tie, there's a reason why that gun was never turned in.
Sure.
Your Honor, my concern is prejudice upon my client, Mr. Stillwell. So if Mr. Copeland is properly instructed beforehand to
To
you know, I
not
don't-
mention Mr. Stillwell's name or,
Right.
or anybody else's name?
and he says the gun was taken and I was not able to retrieve it or whatever, then that solves my problem.
All right. Say are you good with that? And I will I will just tell you that you will need to talk with Mr. Copeland about that. He needs to make very clear that he cannot mention Shannon or anybody else.
And again, given his current, how he's been testifying in court, we don't want to allude. I want him to give whatever answer he's going to give.
But I think you're going to have to tell him that the court has already ruled you cannot say it's Mr. Stillwell.
Okay.
I mean, I think I think that would be a proper witness admonition about that.
Yes.
Or, you could lead him at that point in time.
All right. Thank you, Your Honor.
So you can do both of those two things just to make sure he doesn't get into anything that would be inappropriate. Okay.
Yes. Thank you.
All right. Okay. Excuse me. Okay. All right. Moving on, I think the next thing that we have is 11:45:15 through 11:45:24, which corresponds with page 83, 183, lines 21 through 23.
So we can move forward. I think the next defense redactions are paid.
So are you going to redact those particular portions, or are you not sure? You got, I think under Mr. Sharp's table, it's got unsure.
We're not playing those. I'm not sure.
Okay, so you're not going to play those.
Yes, we're
Okay.
not playing those portions.
All right, so you're going to omit that, and you're also going to omit 11:48:25 through 11:48:34. And that corresponds with page 186, lines 20 through 22, correct?
Yes, Your Honor.
All right, so the next thing, Mr. Sharp, I think we have is page 188, line 9 to 189, line 9. Is that correct?
Yes, Your Honor.
Mr. Sharp? I think that's what I think that's what you all have identified. And your comment is commenting about Shannon doing everything for Thug for free, or worse to that effect. So you want to flesh that out?
Yes, Your Honor. I don't know what Mr. Copeland is specifically referring to when he makes these very generalized statements. But he essentially just goes on to say that my client doesn't have many earthly possessions, which I don't have a problem with him saying that, but he also insinuates that he commits crimes for Jeffrey Williams and doesn't get paid to do so. He just does it to do it. He doesn't give specifics. I'm not sure what he's referring to, and it's bad character evidence, violates 404A and B. And that's why I'm objecting. And I don't know, it's entirely unclear what his personal knowledge to any of this is.
All right, sir. Ms. Hilton? Yes, ma'am. Okay, go ahead. And now what's that, what's the reference on the tape?
So the 11:50 will start a little before 11:50:01 to 11:51 over.
All right.
Young problem right now. Whatever he say, he does it. How much you get paid? Nothing. There's no way. There's no fucking way. It's my mom graveyard. Why? Why is he doing it? He that guy. Guess who told me? Guess who told me what he getting paid next? So. Wait a minute, what?
He said Shannon. Shannon told me. But why, as it sounds, Shannon don't trust you. Why would I tell you anything?
Okay, put it away. He ain't got to sit there. What does he got? Shannon got a truck. He gonna take you for $3,000 to get his truck back. He ain't got $3,000 to go take him. You know what I mean? The shit out here, man. I know Shannon. So I got y'all come around and say, now Woody, come on, man. You right, I don't have to do it. You know what I mean? I don't have to say that you ain't got shit, Woody, but you.
It's at 11:51:06.
Okay, what's the state's theory of admissibility as to that respect?
Your
That
Honor,
particular line, those particular lines.
one, I don't believe that it's character evidence at all. When we start this portion, prior to this particular section, they begin talking about why the opposition was targeting him first, and him being why the opposition was targeting Mr. Copeland first after the murder of Mr. Donovan Thomas Jr. And he's explaining, he being Mr. Copeland, is explaining that it's not me, it's Shannon. And he doesn't say his name. That's when he points to the paper. Because it would appear that on the paper, Shannon's name is on the paper. And he says, this is your problem right here. Whatever he says, he does. And he points to the paper. Presumably, Mr. Williams' name is on the paper and Mr. Stillwell's name is on the paper. They then go in to ask him, how much is he getting paid? He says he's not getting anything. And then they ask him, well, who told you that? And he says, he points, what I believe to be, he points at Shannon, because Dennis clarifies, he says Shannon. He says Shannon. So one, this goes into Copeland's belief of why he doesn't understand why he's being targeted by Ifgang. Because I'm not
He being Copeland?
correct. And he's explaining that I'm not the problem. It's Shannon is the issue. And they're trying to understand more of the dynamic or the relationship between Shannon and Mr. Williams. And he further explains that he's not getting paid. He does, according to Copeland, he's doing whatever he wants just for him. And I believe that again, that is
He being Mr. Stillwell?
correct, is doing whatever it is that Mr. Stillwell is doing for Mr. Williams and not getting paid for it and not, and so I think again, that is important when we talk about this gang RICO enterprise, the relationship between the parties. And what Mr. Copeland is talking about is the relationship between his perception of the relationship between Mr. Stillwell and Mr. Williams. And again, when we're talking about the larger conspiracy and we're talking about the nature of their relationship, the nature of the enterprise, here is arguably an unindicted co-conspirator to the larger gang talking about two other gang members and the relationship between them. We believe that that is relevant for the jury to hear.
John, I'm going to withdraw my objection.
Okay. Mr. Steele?
Well, I'm objecting to everything, but.
Of course. All right. I just wondered if you have another specific objection since it references your client. That's why I was asking you.
I have objections that, believe the court noted. I know Shannon, that's his response. How do you know this information? I know Shannon. He doesn't give any background reason. The state hasn't asked about this at all. And then Mr. Copeland just pontificates and speculates how did Shannon get $3,000? He has no idea. So all of that is wrong. With that being said, though, I don't want to go into Mr. Stark really part of it.
Okay. I've noted your objection. I'll allow the state to play it over objection. I'll give you a continuing objection. And that is page 188, line 9 through 189, line 9 or thereabouts. Okay? All right, next, I think you all have page 196, line 16 through 199, line 4. And that talks about Mr. Stillwell and Dee shooting up houses, about how Mr. Copeland lacks any firsthand knowledge and might be talking about the wrong story.
And Your Honor, this is page 197 to 198.
Page 197?
Yes. And I think we will start at page 197, line 17, and it actually goes to page 199, line 4, and the state has no objection to redacting that portion.
Ms. Hilton, I appreciate that. The way I believe that the conversation, I'm seeing it begin on 196, actually line 1, about D being dropped off at the club. And now, admittedly, D being dropped off at the club is the part of this that concerns me. But I just wasn't sure if you wanted to take out any mention of anything or. I think it all involves the same event.
No, we believe that it's important up until line 121. Excuse me, line 20. Line 17.
I would say definitely we need to start on 14 then. 197 line 14. Where you know what I'm saying. So anyway, what I heard was
Your Honor, we can redact beginning at line 14.
From page 197
Yes, page 197.
to,
After the period, after Big Brother.
so you redact after that?
Yes.
Through page 199, line 4?
Yes,
Mr. Short, you good with that? Anybody else have any objection or wish to be heard about those lines? Okay. All right, Mr. Steele. Anybody else? Okay, all right. Next is page 202, line 5 through 202, line 19. Before we go back there, Ms. Hilton, can you give us the transcript page, the tape references for 197, line 14 through 199, line 4?
Yes, Your Honor.
Okay.
It's going to be around 11:57, 22
To,
to 11:58, 29.
all right, thank you, madam. All right, going back to the next one, page 202, line 5 through page 202, line 19. And I believe that that is comments about Mr. Stillwell carrying a firearm.
Your Honor, given the court's current ruling, we would like it in, but we understand the court's previous ruling.
Okay.
And so I think that would be consistent with his previous.
All right,
ruling.
I'll omit that. Any objection, Mr. Sharp?
No.
Okay, all right, I'll omit that. All right, the next one is page 213, line 20 through 214, line 16. And I believe that that goes to hearsay. Involving, I'm sorry, go ahead, ma'am. Involving the Dexter Montgomery shooting.
For one moment, Your Honor.
Yes, ma'am.
I'm sorry about that. Thank you, Your Honor.
Okay, the page 213, line 20 to 214, line 16 is hearsay involving Dexter Montgomery shooting. So,
And I can play it for the court, Your Honor.
okay,
It'll be from page 213, line 23 through page 214, line 18. And it's gonna be 12:10:51 to
12:10:51.
to 12:11:33.
All right, okay. Go ahead and play it, please, Mal.
It's gonna start a little earlier at 12:10:48.
Yes, ma'am.
They were talking about damn Wayne Bruns. I know OG Bentley shot the boy in the head over there. No, you didn't. Who shot? DK? Nah, this ain't know it. No, you. Two people got caught with sticks. Yeah, no, DK. And why didn't I shoot him? I don't know. They just didn't show a detail. I mean, they just like, no, without me, they don't shot for a question on the record. I like, what murder? I think I killed that gas station in Lakewood. I mean, it's like that. So, but how do you know Nard did it? D? How do you know Nard did it? He said you been his up. They talk about it. I mean, like I tell you, yes, what it was.
And we're stopping at 12:11:34.
All right, State, you want to tell me, go ahead. Go ahead.
I was just going to point out that in this, we've heard testimony about that incident. Mr. Copeland, no one said he was there. He obviously wasn't there. He says his source of information when he was talking to the police was D. I take that to mean there's two Ds. I take that to mean Lil D, meaning Demekion Garlington.
But we don't know.
We don't know for certain. It could also be Quindarius Zachary or another D. But if it's any of those people, none of the people that were there are known as Lil D or D. So he got it from someone who must have got it from somewhere else. And so we're just kind of rehashing rumor and hearsay.
All right, sir. State?
And Your Honor, we should start with page 23, page 213, line 23. The reason that they even get into a conversation about the Dexter Montgomery shooting is Detective Gates. Let me say this, before, let's get to context. This interview is in June of 2015. The police don't know the full details of the Dexter Montgomery shooting till about July of 2015 and August of 2015. And that is, if you can recall, Your Honor, that is when Walter Murphy was interviewed, both in July and August of 2015. So in June, they don't know the full details of what occurred. So Detective Gaither in the line right before this says, I know OG Bentley shot the boy in the head over there, talking about the Dexter Montgomery shooting. And Kenneth corrects her and says, no, he didn't. And she said, who shot him? And he says, they're saying Nard. Nard who? Because two people got out the car with sticks. And he's confirming Nard and DK. And he says, then why did Nard shoot him? I don't know. This is what D's telling me. I believe he's talking about Demekion because either earlier in the interview or later in the interview, he says he gets a lot of his information from Demekion. He says, you know what I mean? They just like Nard went down, Billy went down for a question on a murder, and I was like, what murder? And some nigga got killed at the gas station in Lakewood. You know what I mean? Like that. And then they go in, but how do you know Nard did it? Said D. The reason why we believe that this is important, one, the evidence about the Dexter Montgomery shooting has already come in. The jury has heard that. They heard that over a course of a few weeks back, I think now in April of this year. The reason why this is important, again, Mr. Copeland saying everything he said, he was making it all up. One, this shows that he had knowledge of this gang's activity in 2015. And he's disclosing that information that he knew back in 2015 in this interview. And if the assertion is Mr. Copeland is lying throughout this entire interview, which is what defense counsel has purported or said that they plan on impeaching him on, this shows, one, he's not lying. Two, he knows how to correct inconsistencies or things that are incorrect. And it gives even more credibility to Mr. Copeland back in 2015 when he's giving information specifically about what happened the night of Donovan Thomas's murder. So we believe that the jurors can see from Mr. Copeland's ability to, one, correct the law enforcement officers, two, advise what he knows of the gang's activity is relevant for this jury to assess his credibility, Your Honor.
Your Honor, the fact remains it's still hearsay, and nothing that the state said is a hearsay exception.
Yeah. State, I'm in concurrence. It's still hearsay with no exception. So I'm going to omit that particular portion. From 213 line 23 through 214 line 18, 12:10:51 through 12:11:33. Okay, the next one is page 220, line 11 through 220, line 21. And I want to say that pertains to purportedly bad character, Mr. Stillwell punching somebody else's baby's mama.
Your Honor, the state, I believe the correct lines are page 220, lines 12 to 15, which is 12:15:50 through 12:15:56.
12:15, I'm sorry.
12:15:50
Uh-huh,
to 12:15:56,
okay.
and we don't have any objections.
You're gonna, okay, all right.
And I agree that there are times covered when I was concerned.
Okay, all right. So that's covered. The next period is 222, line 17 through 223, line 6. And that purportedly shows some hearsay in regards to beef with Game and Nipsey Hussle and the squashing of this purported situation. Mr. Sharp, you want to say it? You want to flesh that out?
I have no indication that Mr. Copeland knows or has ever been around the Game, who I believe his government name is Jason Taylor, or Mr. Nipsey Hussle, who's now deceased. But it's certainly a story that he tells that I think there's internet rumors and speculation and everything else, but there's no indication that this is based on personal knowledge, anything more than me Googling street rumors and then saying this is what happened. So there's no personal knowledge. It should not come in. It's hearsay. And it's speculation.
All right, Ms. Hope?
Yeah, I'll play the section.
Okay.
And we're gonna start a little earlier at 12:16:59, but the relevant portions will begin at 12:17:08.
You said what, I'm sorry, one more time about the
We're starting earlier at 12:16:59, but the
12:16:59,
relevant portions will begin at 12:17:08
and you're gonna play through,
through 12:17:31.
all right, thank you. Okay, go ahead.
Nobody care about nobody. You know what I'm saying? Don't take shit from nobody.
Well, how did the beef with Game in here?
The game league is shut up and do it with Joe Shan do it. Shan told me his mother was up there winning.
Just give me the word.
Yep. And Doug told him no. Say something on the GD, I can't Nipsey Hussle, something like that. He ended the beef. You know what I'm saying? He stopped. You know what I mean? I ain't here to play. You know what I mean? I just don't want to go to jail.
And we stopped it at 12:17:35. And so what we have here, Your Honor, is actually two party opponent admissions. So Detective Dennis asks, well, how is the beef with Game and them? And Copeland says, well, the Game was fixing to get shot up if Thug would have told Shannon to do it. Shannon told me out of his own mouth, he was up there waiting. Just give me the word. Yep, and Thug told him no. said talking to him, GD, I can't really say like Nipsey Hussle or some shit like that. He ended their beef. You feel what I'm saying? He stopped it. You know what I mean? I ain't here to play. And Your Honor, if you can recall, we already have in evidence the video of Mr. Stillwell in the car threatening the game that has already been introduced. So this is further corroboration of that video that has already been entered into evidence. And Copeland saying that Shannon was ready to act on behalf of the gang for Mr. Williams, if Mr. Williams would have gave him the go ahead, but Mr. Williams told him not to do it. Sure.
Yeah, sure, absolutely.
They should know that.
How did the beef with gang in?
The game league is shut up and do it with told Shannon do it. Shannon told me his mouth was up that way.
Just give me the word.
Yep. And throw it to him, no. Say something on the GD, I think Nipsey Hussle or something like that. He can't be. You know what I'm saying? He stopped. You know what I mean? I ain't here to play. You know what I mean?
And we concluded the playing again at 12-17-34.
All right, Mr. Sharp.
I don't hear exactly what Miss Hilton hears. I can't say I hear something different. I can't make out where she's saying that Shannon or that Kenneth said, told me out of his mouth. But it's hearsay unless we can identify the source of his knowledge and it falls under a hearsay exception. I don't believe that this statement does that. I believe that he's speculating based on what he's heard from, as I said, from the internet or rumors or street rumors. But the other thing I'll say, it's also not an admission by a party opponent in and of itself. And that's because the hearsay that I'm concerned with is Kenneth Copeland's hearsay. And he's not a party opponent. This is hearsay. And this never came up at all, to my recollection, in direct examination of Kenneth Copeland. So there's been absolutely no foundation laid.
What about the earlier video with your purported your client?
Well, that was
talking in the car about, hey, I think this is the one. If this is the one,
that was admitted over my objection.
Yes.
And my objection to that is still the same, and I guess I should probably reiterate that as well. This alleged incident involving the game is not charged as an overt act. There's no police reports in the discovery, to my knowledge, is just this video with nothing else. So there's really no, I know that the state wants to take a very expansive view of what a RICO prosecution is, but again, they named 191 overt acts. Nothing involving the gang was named in the indictment, and there's no police reports regarding threats to the game or anything else. There's just this one video that's pulled off of some website somewhere and thrown into discovery. And I don't believe that it's intrinsic to anything, and I don't believe it's relevant. Now, obviously, Your Honor has disagreed with me, and Your Honor let in over my objection the video. But just because that has occurred doesn't mean that I agree that other conversation and hearsay conversation by Mr. Copeland should be bootstrapped into this trial just because we've admitted one video over my objection.
Yes, sir. Okay. Ms. Hilton?
Your Honor, again, this is corroboration of the overall conspiracy of the gang. You're right. I think that sometimes maybe stream away from, there's still an overarching conspiracy of the gang itself and the activities that the gang does. And so the court, even over objection, admitted evidence of Mr. Stillwell threatening the gang on video. Here, Mr. Copeland, and this says, and we can play it again for the court, Shannon told me out of his mouth. So that is
What line is that?
this would be
Page.
line 20 on 222, but where it says indiscernible, if you actually listen to what he says, and I'll play it again.
Play that portion, just that portion
Yes.
again. Hold on. I'm too far.
I'm going to start it at 12:17:06. Oh, sorry.
Care about nobody, you know what I'm saying? Don't take shit from nobody.
Well, how does the beef with gang in here?
The game lead is shut up and do it. We told Shannon do it. Shannon told me his mother he was up there winning.
Just give me the word.
Yep.
And I can play it again.
The game lead is shut up and do it. We told Shannon do it. Shannon told me his mother he was up there winning.
He said Shannon told me out of his mouth he was up there waiting. Prior to that, he says the game was 50 and shot up, and if Thug would have told Shannon to do it.
Christian. Can I listen to your? I'm gonna see if I can hear it from Ms. Weaver's vantage point, and I'll invite anybody else to listen to it. Let me just see it. Huh? Yeah. I'm gonna listen to it first, Mr. Adams, and let me just see whether or not I can hear it. If I can't hear it, it's no sense in you listening to it. Okay?
I'm going to start at 12:17.
You're not ready.
Oh, not ready yet? Okay.
Working last time.
Of course.
Oh, wait.
All right, you can play it now.
Well, how does the beef with gang in here?
The game lead is shut up and do it. We told Shannon do it. Shannon told me his mother he was up there winning.
Just give me the word.
Yep. And Thug told him no. Say something on.
Keep on going. You want to keep going?
No, Mr. Adams, you want to listen to it?
You hear better?
Yeah. I think at least from what I hear, he says, Doug told Shannon to do it. So go ahead and listen to it. Any other counselor who wants to come and listen to it, you're welcome to do so.
And I don't believe that. I think he said if Thug would have, they were about to get the ass shot up if Thug would have told Shannon to do it. Shannon told me out of his mouth he was up there waiting, and then Dennis responds, just give me the word, give me the word. That, and Thug told him no, so I want to be clear. I think Mr. Woods told him no, but he was prepared to go. I'm gonna start at 12:17:05.
You know that.
Well, how does the beef with Game in it?
The game nigga did shot up his door with told Shan do it. Shan told me his mother was up there winning.
Just give me the word.
Yep. And dog told him no. Say something on the GD, I can't Nipsey, Nipsey Hurston, something like that. He ended beef. You know what I'm saying? He stopped.
Stop at 12:17:31.
Hold on a second, sir.
Stop at 12:17:31.
Can I listen to it one more time? All right, Mr. One more time. Please.
I'm gonna play it starting at 12:17:06.
Well, how did the beef with Game in it?
The game nigga did shot up his door with told Shan do it. Shan told me his mother was up there winning.
Just give me the word.
Yep. And dog told him no. Say something on the GD, I can't Nipsey, Nipsey Hurston, something like that. He ended beef. You know what I'm saying? He stopped.
I stopped at 12.
I think it's, all right, this is what I hear. Shannon says I was up there waiting. One more time?
Can you turn it up? Volume.
Turn it down. It's working a little bit. Go ahead, one more time.
All right, I'm gonna start again at 12:17:06.
Well, how did the beef with Game in it?
The game nigga did shot up his door with told Shan do it. Shan told me his mother was up there winning.
Just give me the word.
Yep. And dog told him no. Say something on the GD, I can't Nipsey, Nipsey Hurston, something like that. He ended beef. You know what I'm saying? He stopped.
One more time. It started a little bit earlier at 12:17.
Dog ain't take shit no better.
Well, how did the beef with Game in it?
The game nigga did shot up his door with told Shan do it. Shan told me his mother was up there winning.
Just give me the word.
Yep. And dog winning. Do it. Shan told me his mother was up there winning.
Just give me the word.
Yep. And dog told him no. Say something on Shan told me his mother was up there winning.
Just give me the word.
Yep. And dog told him no. Say something on shit know that.
Well, how did the beef with Game in it?
The game nigga did shot up his door with told Shan do it. Shan told me his mother was up there winning.
Just give me the word.
Yep. And dog told him no. Say something on the GD, I can't Nipsey, Nipsey Hurston, something like that. Yep. And dog the game nigga did shot up his door with told Shan do it. Shan told me his mother was up there winning.
Well, how did the beef with Game in it?
The game nigga did shot up his door with told Shan do it. Shan told me his mother was up there winning.
Well, how did the beef with Game in it?
The game nigga did shot up his door with told Shan do it. Shan told me his mother was up there winning.
All the, I
Just give me the word.
up there, it's the last part, that last sentence. I can't hear the first part.
And I don't hear what the state's saying, and I don't even hear enough syllables to get to where what the state's saying. I will stress the obvious, which is in an indictment where an overt act alleged is the shooting of a high profile hip hop entertainer's tour bus is included. This statement, the admission of this statement is highly prejudicial against my client. I don't hear anything in the statement that cures the hearsay aspect of this statement. And I still say that Mr. Copeland is giving information. The end of this, by the way, the end of this statement is, I want to get out of jail. That's how he ends this, right when the state's turning it off. He says, I want to get out of jail. He's giving all sorts of information that he knows, but he's not a lawyer. He's not limiting it to personal knowledge, and he's passing on hearsay that he thinks he knows, I should say, and it shouldn't be admitted for that reason.
Mr. Adams, what were you gonna say, sir?
Just to add to the record, I would say that listening to that the number of times I've listened to it, I did not hear what the state says that they heard.
I didn't hear it either. All I can hear is that last little bit.
Yeah, I'll tell you that I heard one of two things. Either Shannon and them was on Metropolitan waiting for him, or Shannon was probably up there waiting.
That's what I thought I heard, but I can't be certain. I can't be certain because I can't hear the first part of it.
But I'll tell you, I'm not 100% certain of this one of those two. I know I didn't hear the state said they heard. He came out. Shannon told me out of his own mouth. I didn't hear that.
You're right. And I can play it again, but if you read it in context, that's what makes sense. Literally says
But I gotta be able to hear it.
Yeah, and I'll play it again, but this is the context of it. The game was fixing to get his ass shot up if Thug would have told Shannon to do it. Shannon told me and I'll play it again, out of his mouth, he was up there waiting. And Dennis responds, just give me the word. Cobra says, yep. And Thug told him no. So when you read that in context, that is the only thing that he would have said is Shannon told me that he was waiting for him. And we can play it one more time.
The only word that could have been said. And again, I think he didn't hear. Nowhere do I hear out of his
Metropolitan, but we can play it again.
All right, so let me hear whether or not I hear out of his mouth or Shannon something Metropolitan waiting for him. Okay.
Can you slow down? Maybe we can slow that down.
The slowest it goes is 1.6. We were trying to see if it goes to 0.5, but it doesn't go slower.
The game lead is shout out to Thug with told Shannon do it. Shannon told me smiley result that winning.
Why does the beef with game in it?
The game lead is shout out to Thug with told Shannon do it. Shannon told me smiley result that winning. Thug with told Shannon do it. Shannon told me smiley result that winning.
Just give me the word.
Shannon told me smiley result that winning. Told Shannon do it. Shannon told me smiley result that winning. Do it. Shannon told me smiley result that winning.
Just give me the word.
Shannon told me smiley result that winning.
Just give me the word.
Yep. And Thug told no. Say turn on. Shannon told me smiley result that winning.
Just give me the word.
Yep. And Thug told no. Say turn on the GD. I can't Nipsey.
Oh yeah. Miss Weaver has told me, authorized for me to tell you that you see how difficult her job is. Okay, so I'll be honest with you. I don't, Ms. Hilton, I do not hear out of his mouth anywhere. But I, but I have to be honest and say, I don't hear, I get beat. I like Mr. Adams. I get little bits and pieces of Shannon and then waiting for him. I don't get like that, the rest of that sentence that fills in. I can't hear it, or at least not now. Okay. All right. Thanks for y'all indulging and letting me hear it a bunch of times. Okay. In considering line 220, I should say page 222, line 17 to 223, line 6, and corresponding audio video portion 12:16:59 through 12:17:35 in regards to this beef with Game and Nipsey Hussle squashing it. Okay, the defense's contention is that there's no personal knowledge. It's hearsay and they believe it's speculation. And then the state asserts that these are two admissions by party opponents, and it corroborates the prior discussions and gives overarching relevant testimony on the conspiracy of the gang and its activities. The court's in concurrence with the state's assessment, so I'm going to allow it over objection. I'll note, Mr. Sharp and others, it will be a continuing objection.
And Your Honor, just for the record, also, I objected based on lack of foundation.
Yes, sir. Yeah, I will add that as well, that you did object as to lack of foundation. Okay, all right. I want to say the next statement is page 230, line 20 through 233, line 4. And then it's page 234, line 19 through to 238, line 25.
Your Honor, could we have 5 minutes before you go on to the next?
Yes.
Thank you.
Yes. We'll be in recess for the next 5 minutes, okay? All right. All right, councils, I think when we left off, we were about to discuss page 230, lines 20 through 233, line 4, and page 234, line 19 through 238, line 25. Okay, we ready? All right. So, I believe that's hearsay in regards to the Lil Wayne bus shooting. So where are we, councils?
Your Honor, the state has, the state has we would like in to complete the thoughts on page 230 up to line 23. Because I think defense counsel starts at 230 line 20.
You said 230 up through line 23?
Yeah, so we want all of up to line 23 in, and then starting at line 24, we don't object from 230 line 24. And we have actually initially to 233 line 24.
All right. So, Mr. Short or others, you, Mr. Steele, any other, the state wishes to just, they want to play through, they want to play up until 230 what, madam? 230 line,
So 230 line, starting the redaction at 230 line 24.
you want to,
I don't have any problem with that.
okay, going through 233 line 4?
Going through. Going to 233 line 24.
I don't have any problem with that.
So going to 230, page 233 line 24.
Yes.
All right, and what transcript, or I should say, I'm sorry, what audio, video portion does that correspond to?
It's going to be, and I'll just need to confirm around 1223, probably around 40,
Okay,
but I'll need to double check it until 122608.
all right. All right, what about page 234, line 19 through 238, line 25?
no objection from course indulgence. No objection from 234, line 19 through 238, line 25.
May I make a suggestion? I'm in agreement with everything the state has said. It leaves this patch between 234 line 4, 233 line 4 and 234 line 19. Excuse me, let me try that one more time. It leaves a patch 233 line 25 to 234 line 18, which is about 18 lines. And it's just completely out of context without any relevant information one way or another. So I would suggest we just redact from 230 line 23 all the way to 238 line 25.
Okay. That's fine, Your Honor.
So what are the redactions to, madam? I'm sorry.
So I think we're really starting back at 230, line 23.
To
Through 238, line 25. And that's going to be 1223, so approximately 40 to 1230. I think it's going to be 15.
okay. All right, Mr. Short, I think the next and others, I think that the next period that the state is going to. Are you admitting this, Ms. Hilton? That's 12/25/30 to 12/25/36.
So Your Honor, those two are all inclusive of what we just discussed.
Okay, all right, so we don't need to worry about those anymore, okay? All right, what about the 241 line 3 to 242 line 21? And then I've got 243, I guess, pages 243 to 248, line 11. And then it's okay. So let's talk about those next. Yeah, Mr. Shaw, I think you've got discussion about not relevant matters.
Right. So, as known, Mr. Copeland tends to jump from topic to topic sometimes, and 242 towards the bottom of the page, 241, he starts talking about how the owners of Club La Cora thought that he had shot at the club or into the club, and it was one of Pee Wee Longway's people that had actually done it. And it's a big story about how he had to prove to the Allison brothers that he wasn't the one who shot, and it was proven by videotape that he was wearing some other types of clothes. And then he also talks about Tick robbing Bentley for a necklace. So that's all mentioned in the first part of what I would like excluded.
That's the 241.3 to 242.21.
Yes, sir.
All right, let me hear from the state.
From 241.3 through 242.21.
Yes.
So, Your Honor, we would agree from page 241, line 3 to page 242, line 18.
Okay. What's your stance on that, Mr. Sherman?
Well, the problem is, in there is a small area where Mr. Copeland and the detectives start talking about loyalty and how he's loyal to his friends and how these other guys weren't raised the same way he was. But then they immediately after 5 lines or so, they start going into Bentley. He says Thug got his necklace back.
Yeah, I think that that's all part of what they're not going to play. They're saying they want to stop it at 18 as opposed to 21.
Right, but then it picks up again, the second part of,
And that's 243.
right, and then they're talking about Thug going to what's the name spot with a whole bunch of choppers, and got his gun, got his necklace, and then they're back on the Allison brothers, talking about the Allison brothers, and then he's back on the topic of shooting up LaCora again on 244. So, there's a couple lines, I guess, that could be played. The bottom of 242, the beginning of 243, but again, it's kind of like the last one. They're sandwiched in between two sections that I feel should not be played, and I don't know, standing alone, how much context or value they have.
Okay, anything else, sir? I'm going to get the state's.
No, that's it. I guess I need to hear what the state's view on the second part is, and then we can figure out if there's any use of keeping that little bit in the middle.
Okay, all right. Ms. Hilton, what's the state's theory of playing 243 to 248?
I'm sorry, I didn't realize we were on 243. 243, 240. I thought we were still on the decision regarding.
Can you turn your mic on?
I'm sorry.
Decision rather in regards to 18 versus 21?
Correct, because
Okay.
I don't think.
Let's see if we can get to the other one, and I think the defense is going to go back to that.
But
whether or
from
not we're-
243 line 9 through 250,
You said 243 line 9 to what?
from 243, from 243 line 9 through 257. Well, let me start here. From 243 line 9 through 248, the state has no objection to.
To the end, so 248 through line 24? I guess that's the end of the page, right?
Yeah, so 243 line 9 through 248 line 24, the state has no objection to.
Okay, all right. Okay, and then what did you have some other lines that you didn't have any, or you wanted to also say you were gonna omit?
Course indulgence for one
Yes, ma'am.
moment.
So, Ms. Hill,
Yes, sir.
the question I was posing earlier was between 242 line 22 and 243 line 8. Does that make any sense in isolation, or should that be redacted?
So I was still wanting 242 line 15 through 243 line 7.
You said 242 what, ma'am?
Line 15 through 243 line 8. I'm sorry.
That's fine, Your Honor.
All right. Okay, all right. Anybody else have any discussion or objection as to those pages, 241, 3 to 242? Okay, all right, sir, thank you. Okay, what about, all right, so continuing, Ms. Hilton, from 248.
By changing it, I suggested 248 line 11, the state put forward line 24.
Okay,
And that chops off the first half of the conversation regarding Shell Cal and Tay shooting each other. I don't have a strong opinion about whether it comes in or not, but I would suggest if we're gonna take it out, we should just take out the second part of that conversation. If we're gonna leave it in, we should leave it in the first part of the conversation. I think it's all hearsay, so.
Your Honor, the state has 256, line 7.
All right.
That seems appropriate on behalf of Mr. Still.
All right. Okay, then the next period we need to discuss is 266, lines 10 through 24, where there's some hearsay about Mr. Copeland and Mr. Williams and this apparent gun buyback.
Right. So this is regarding the gun that was left at the rec center, I believe. And Mr. Copeland says, I heard that Thug was told Lil D go back and get the gun, like from Indiscernible, You Feel Me? That's 266 line 10. And so what what he's saying to the detectives is that the plan, to his understanding through hearsay, was that Thug, Mr. Williams, instructed Quindarius Zachary to try to go buy that gun back from Kenneth Copeland, the assault rifle. So, in Kenneth Copeland's own words, it's something that he has heard. I don't know. It doesn't appear that he was a party to any negotiations or anything like that. That's just something he heard, and that's hearsay.
All right. Ms. Hilton?
Your Honor, we're in agreement of page 266, line 10 through 13. Which is the portion, Mr. Sharp is still page 266, but the portion which he does say, I heard, is page 266, line 10 through 13.
And I don't have a problem with that, except on 266, line 23, he goes back to repeating the hearsay.
You should listen to that portion, so he's repeating.
I can't understand.
Well, he said, so Thug was like, go get that gun, feel me. And he's already identified that his source of knowledge of Mr. Williams supposedly ordering to go get that gun was hearsay, so seems like we would take that out. I don't have a problem with leaving the rest in from 14 to 23, except for that line.
I'll play a portion. We believe this could be categorized as co-conspirator hearsay as well.
Are you talking about from 13 through 24?
Yes, 13 through 20. Yes, 13 through.
Because you're agreeing that 10 through 13 should be omitted on page 266, but you want to play, I guess, 14 through 24. Is that correct?
Yes, Your Honor. But we do, I mean, now looking at it all, 10 through 24, we believe could be co-conspirator hearsay. But given that we just told the court, we could omit 10 through 13, we'll play 14 through 24.
All right, let me hear that then. And what transcript, I should say, video transcript references does that go to?
It's gonna be about 12:51, 13
To,
to 12:21, 30.
you said 12:51:13 to 12.
51, 30.
Okay, thank you. All right.
It's gonna start a little bit earlier, around 12:56.
Yes, ma'am.
I should have used that nigga right there. Should have. I ain't gonna lie, man. But really, at that point, it really worked because it was kind of still yours. Had you got your money yet? Huh? Because they were gonna pay you. Right? This what I did here. I heard it. So, totally did go ahead and get done. Like, from the house, you hear? Somebody, see, you know what I'm saying? Like, every time I start having, they call it good. Huh? Yeah. Yeah. So every time I start having, somebody was trying to do it, test stuff. So, do it like you go get the gun, you did. So that's what I'm saying. If you came in,
And then we just play at 12:51, 31. Brian, we'll admit, we will omit from 12:51, excuse me, page 266, 10 through 24.
Through 23? On page
Yes.
266?
Yes.
All right. Mr. Sharp, anything further?
No.